Hello, fellow Toolboxers. Welcome to episode number 394. This is a special episode I wanted to get in, and we're just going to jump into it because two policy memos or policy manual updates came for USCIS just this week. I'm recording this Saturday night on August 2nd. One of them was for family-based immigration cases, where there's a policy alert. A second one was for adjustment of status for asylees and refugees. I'm going to go over the first one. The latter, I'm not going to go over. It's not my specialty per se, but when it came out, I got really worried. So I want to go over the details because obviously there's lots going on with the administration, adjustment of status, people who have, periods of authorized stay, all this stuff. I want to jump into it, dig in deep to see what has changed. And so what I did is I got all the pages for the new policy manual. I went to the Wayback Machine as a way to check out websites way before to compare them side by side. I can't say I'm going to do like 100% accurate difference, but I did I spent like half an hour right now going through both and take a look. Overall, wasn't anywhere near as bad as I thought. A lot of it's just procedural stuff, but judge for yourself and then take it from there. I'm sure there's different ways administration is going to make it worse than I think it is, but let's just start with that. For those who haven't seen the show or didn't know about me before, I'm John Khosravi, immigration lawyer in Los Angeles. My law firm, JK Law, but also have the Immigration Lawyers Toolbox, which is an organization for promoting immigration lawyers and the practice for as a trade associate group, if you will, for us. We have a podcast and videos, a magazine, a quarterly magazine, community page, courses on how to do various aspects of immigration law. So for lawyers who want to get into immigration or just step up their game, we help support you. Go to our website, iltbox.com. That's short for immigrationlawyerstoolbox.com. And if you want to join the community page, it's free. It's on a different website to get off Facebook. I've done that. It's Circle SO. Just email me with your bar information, state bar number, full name, and the state that you're a member of. Info@immigrationlawyerstoolbox.com. None of the information provided here is intended as individual legal guidance. You should consult with an immigration attorney on your own, but y'all know that already. So I'm going to share my screen right now. I'm not sure how well it's going to come through, frankly. Let me just close this so it's not a million screen shares. So I can't see what I'm sharing right now per se, so you can see it, but I'll try to read it. So this is the policy that came out. It was very vague, usually very much more specific on what's being changed. And so when I saw that, I'm like, okay, I guess I got to spend the time to just review the summaries to see what's different. This was issued August 1st, and it's August 2nd. I'm reading it. The website as well has its clarifications of what's going on. There was some worries that, should I get to it now? If someone's on ESTA, I saw people posting on Facebook, can you adjust that? There's nothing that says you can't. The biggest fear just jumped to is if you have an I-130 pending and you want to do a 601A waiver, they kind of say, we could pick them up because they don't have a status, and I-130s don't give status. But this is a worry that we've been having for months now. So this one per se wasn't that big a change. All right, so let's jump to Chapter 1. Chapter 1 previously on the Wayback Machine is on the right if you're watching this. Wasn't much there. They added a little more stuff on purpose, which I'm going to read, and then background about the immigration system, which was generic, and then C, legal authorities that they added because they added to these upcoming chapters. So, the USCIS policy manual, there's multiple volumes. Volume 6 is for immigrants. Part B is for family-based immigration. And so chapter 1 of the 5 chapters, more than 5 chapters, but chapters 1 through 5 are the ones that were adjusted. They added legal authorities in subsequent chapters, so they listed here. The one I highlighted was revocation for approval of petitions because they got into revocation and stuff. But that doesn't necessarily pop up too much. The big deal on this page is first they say family-based immigration accounts for most new LPRs with immediate relatives alone, making up approximately 40% of new LPRs annually. So immediate relatives, parents of U.S. citizens, spouse of U.S. citizens, minor children are 40% of green cards issued annually. So that's interesting. Then they add this line here that says fraudulent and frivolous or otherwise non-meritorious. Why am I talking like this? Sorry, it's the middle name right now. Fraudulent, frivolous, or otherwise non-meritorious family-based immigrant visa petitions erode confidence in family-based pathways to LPR status and undermine family unity in the United States. Therefore, USCIS must ensure that qualifying marriages and family relationships are genuine, verifiable, and compliant with all applicable laws. So, okay, you got to throw that in the beginning, okay. Heads up, I wanted to share this. I did take, what you're reading, if you're seeing on the left, if you listen on the podcast, which most people do, you won't see this, but on the left is a screenshot I took and I edited. We got mosquitoes in the house. Did I get it? No, sorry. The mosquito season's here in LA and they're driving me crazy and I really want to stop the program, just go kill the sucker, but I'll let it buzz around me and hopefully it doesn't get me too bad. All right, so going back to what we're talking about, The software I use, I have two Chrome extensions I've learned about all, from colleagues or somewhere. One is called Print Friendly, and so if you go to a website page, you I don't get paid from these, but just I want to help. Chrome extensions. You click that, it'll do a save the screen in a printer friendly, in a like a friendlier version. Because sometimes when you save a PDF, it looks all weird. But I almost 99% of the time use this other one called Go Full Page, and it just goes through the page and it makes it into a PDF, and it's just really helpful for my petitions. We do it for cases. Just personally, it's just a better way of saving PDFs, because I know it can be a hassle if you try to save it. So Go Full Page is the name of that one. All right, going back. So the purpose and background, the annoying part is just fraud, frivolous stuff. Is like, okay, that's unnecessary, but okay, whatever. So let's move to chapter 2. Wayback Machine, you all know, is just holds old website versions and stuff like that. Chapter 2 previously was all blank. So they filled it up, but from my reading, it was just the basic laws of how family-based petitions work and what to be mindful for. I didn't see any red flags or smoking guns of anything too crazy happening. It was just kind of explanation of the system. They had put it off, I guess, filling it out. Now they call it Chapter 2 General Eligibility Requirements. Before it was called Principles Common to Family-Based Petitions. Okay, and in the memo they go chapter 1, chapter 2, and then chapter 4. So I'm going based on that. So I'm going to skip chapter 3. We're going to go back to chapter 3. Chapter 4 is empty as well. It was called Documentation and Evidence for Family-Based Petitions Reserved. Now it's just Documentation Evidence. So everything's new on it. They have a part here, though, that stands out. For instance, USCIS has the discretion to deny a petition without issuing an RFE or NOI, notice then to deny, if there's no statutory basis for approval. Okay, that's easy enough. Or for failure to submit initial required evidence. This was a fear we had during the first Trump administration. If you forget to send a picture or something like that, or what they interpret as initial required evidence. Some people, I guess, may forget to send a marriage certificate and stuff could lead to denial. And this has actually changed our habits. In LA, it takes like 6 to 8 weeks, sometimes San Francisco too, to get the actual marriage certificate. So before Trump 1 administration, we would have people get married, and we would send a copy of the registration paperwork. Not because, at least in these counties here, you get married, that they sign off, but it's not the actual marriage certificate. It's like a registration, but it's something that's not the actual marriage certificate. I've ever done. But so we would send that in and say, listen, when the interview happens, we'll do it, because that time they're always doing interviews. Or they'll just RFE and we send it then. But at least that would speed it up our ability to submit the case if there's deadlines or just want to get it in. But after last time they said, failure to submit initial evidence, we just said, okay, you guys got to get married. And tip for those in California, we tell people go to non-LA and San Francisco counties. So in LA, we go to Ventura County, Santa Barbara, Orange County. Those are in order of how fast. Ventura County does same day, Santa Barbara the same week, and Orange County could do the same day a week. If you ask them really nice, they'll probably do it the same day anyways. In San Francisco, yeah, you just go to neighboring counties, you do that. But that's that. And then it says, however, USCIS must provide the petitioner with sufficient detail of any derogatory information that is unknown to the petitioner when USCIS intends to take adverse action on a family-based petition. Okay, they hold their feet to the fire a little bit there. And then there's a piece of information that's good to know. It says when you want to prove someone's citizenship, a copy of the petitioner's current unexpired U.S. passport or passport card. So just to note, it has to be unexpired. I've had clients pass, oh, my passport expired, and we just said, to be safe, just renew it, then we can file or find your birth certificate or whatever. But here it's official. It has to be unexpired. And then here it goes, types of evidence for family-based immigrant visa petitions. Says if a petitioner does not provide primary evidence in support of a family-based petition, USCIS generally only considers other records as secondary evidence if primary evidence is determined to be unavailable or unreliable. This is a typical thing we see on the visa reciprocity chart. If the birth certificate is unavailable, unreliable, typically it's more for police certificates this comes up. But I guess for India, for example, birth certificates for India, we always have this issue. As you know, older people there don't have birth certificates, or they have delayed birth certificates. It says petitioners may also submit 2 or more sworn written statements, affidavits from third parties who have personal knowledge of the event and circumstances establishing a claim relationship, such as a date and place of birth, marriage, or death, if both primary and secondary evidence are unavailable. So it's important you have to send a copy of the visa reciprocity chart that says those are unavailable. So that was chapter 4. Going to chapter 3, there's this for filing, and they reorganized some internal parts of it, so move some chapters up and down. But they have one part they added here. It says a beneficiary of a family-based immigrant petition may concurrently file to adjust status in certain circumstances. For example, since the immediate relative are not subject to numerical limitations on a visa availability, Nothing actually. They just added this part in this. I'm sorry, I'm reading it. So it's nothing that's big or just like, okay, do concurrent or you can't. But they added this paragraph in the middle with more specificity. And then there's a part where it asks about when the U.S. Department of State is authorized to accept and adjudicate Form I-130. This is so-called direct filing, or the terminology used, the FAM. But it says a clearly approvable petition is generally one that includes sufficient primary evidence to establish the status of the petitioner in the qualifying relationship. This policy applies even in countries with the USCIS presence. Without such delegation, the U.S. has no authority to permit the U.S. Embassy or consulate to accept local filing abroad. I thought there was a petition established. So it doesn't really go too far away from what they had, except that's that thing that was in line that they added. Pausing, wait, let me pause it really quick. I thought I read something differently when I was reading this. Okay, so it just says USCIS has delegated authority to accept it, even, and then they're giving the authority to it. So that the wording's kind of weird, but it doesn't make a difference. Then there's part here they added, if DOS accepts a petition, USCIS must receive notice of the filing and information about the basis for local acceptance. Okay, I mean, is that the embassy sends that? I'm assuming. And then you don't do anything. Then exceptional circumstances, it's pretty much overlaps what was there. This blanket authorization part, they moved it to section B here. That's the only big thing there. There's this language here that kind of confused me. It says if DOS accepts a petition on this blanket authorization, blah, blah, blah. The blanket authorization does not apply to U.S. service member or USG employees stationed or assigned to non-executive branch agencies or exceptions or exclusions to the Chief of Mission Authority, okay, whatever, or non-military bases such as internal organizations of civilian institutions. Okay, that's good to know. This is the part where I'm going to get to. It also does not apply, this exceptional circumstances, direct filing. It also does not apply to service members who are on temporary duties or duty orders or assignments. So I'm not a big military. I handle a lot of these military cases. Honestly, every time I try to do a direct filing with a military case, these embassies in Europe have found ways to say we're not going to do it. So I end up like in Italy. They're like, no, don't do it. I'm like, what do you mean? And then I had London said, oh, you have to file like a month before they're going to leave. So if they have like a year of duty, you have to wait till the end. So we just said, okay, whatever, we'll just do a regular I-130 with USCIS. But here it says, a service member stationed at U.S. military abroad on official orders, but then it doesn't apply to temporary duties or assignments. So I might just be misreading that, misunderstanding that. That was kind of weird. And then this multiple petition part was added, which is, I'm showing my lack of understanding of some of this, but I'm not sure when exactly this come up. There is a part of the HCFR, which I did a podcast on 2 months ago, that said you cannot have two petitions from the same petitioner and the beneficiary happening. So this kind of goes afoul of the CFR language right here. In the past, I have submitted two petitions where the first petition, the person had put the wrong, they said they want to do adjustment of status, but needed constant processing. This is years ago when like you can't just easily fix that. So I said submit a new I-130 to be safe, stuff like that. But here it says multiple I-130 petitions. USCIS regards, if you have two and the seconds they're both approved, USCIS regards a subsequent petition approval as a reaffirmation or reinstatement of the validity of the first petition. Prior to approving, reaffirming, or reinstating a subsequent petition filed by the same petitioner for the same beneficiary in the this is hard reading petitioner, repeating myself. But essentially, I'm not sure when this come up. They say the original priority is retained unless the original petition was terminated by DOS. So if you have two approved, the first one goes, and then petition submitted concurrently for other relatives. If the petitioner indicates on the form I-130 that he or she is filing petitions for additional alien relatives at the same time, the officer considers all the petitions simultaneously if possible. Well, yeah, probably, yeah. So I'm not sure why they get into in this, what kind of scenarios it pops up where this really comes up. But this is one of the changes that happened there. Then going to chapter 5, they added a bunch of parts at the beginning, like A, B, C, and D used to be not there. They added A is still blank. They added an interview section, which is kind of generic that they're doing interviews and stuff. And then they have decisions. One note is they used to be, they probably changed their Biden's time because the Congress passed a law that said don't use alien or they, I'm not sure they internally did or Congress passed a law where they said call them like don't call them alien, it's offensive. So in the old policy manual from 3 days ago, there's this line that says the beneficiary's history or character is also usually not relevant to the adjudication. History or character, I think. What about? I guess not for an I-130, unless it's the Adam Walsh Act. But for adjustment of status, good moral character, you can. The new language is this: the alien's history or character. So they substitute the word beneficiary alien. Okay, and for some reason, or history or character, but that's that. So I just thought I'd mention that. Not a big deal per se when it comes to the law. And then when you go down, essentially this is it. They have this post-decision actions thing, which I'm not going to get into, but about withdrawing and revocations and stuff. It wasn't that groundbreaking for my again, I haven't read it in full detail, but I just kind of skimmed it. They have this appeals and motion part that says, however, if USCIS revokes, oh yeah, this is annoying. So, however, if USCIS revokes upon notice the approval of a family-based immigrant visa petition, a petitioner has a right to appeal the decision within 15 days after the service of notice of the revocation. So you only get 15 days if you get a revocation notice, which sucks because you're not expecting a revocation to happen. You might not be checking the mail. That's kind of a nasty thing to put in there for just 15 days, but it is what it is. The biggest part, I guess, that's controversial is this part, removable aliens, section 3 under C. If USCIS determines that the alien beneficiary is removable and amenable to removal from the United States, USCIS may issue a notice to appear NTA placing the beneficiary in removal proceedings. Petitioners and alien beneficiaries should be aware that a family-based petition accords no immigration status, nor does it bar removal. So the first part is amenable. Does that mean if they're down with it? Or I looked up the definition of amenable. I'm like, am I not reading this right? But essentially it opens that up. If you filed I-130, they're out of status. They reserve the right, what do they say, may issue. And that's a problem. So are we going to throw out I-601As? Why have a form called I-601A? I mean, it was made by President Obama at his time. It wasn't like a congressional thing, but it exists. So how could you have a form that exists for something that you prevent people from getting it? But we're seeing that's the crazy part right there. So what do you do with I-601As? We have I-130s pending where 601As are going to happen the next step. What are going to happen with those? So that's the biggest change and most controversy. That's why I said at the beginning of the show. I just want to get straight to where the beef is. But that's that. So I want to share this information with the practitioners because I know it's stressful. We don't have time to go through in detail and compare it. So I thought I'd jump a video and do it real quick. If you didn't know us about us already, Immigration Lawyers Toolbox, it's where you get your information about immigration law, magazine, podcasts. We help promote you, get more name notoriety out there. And just help other practitioners become better immigration lawyers. If you want to reach out to me, info@immigrationlawyerstoolbox.com is my email, info@immigrationlawyerstoolbox.com. I'm immigration lawyer John Castravi. See you next time.